The Guantanamo prison is located on 45 square miles of land on the U.S. naval base in Cuba. It opened in 2002 under President George W. Bush. This is where both prisoners and suspects of terrorism are held, especially a suspect from 9/11. This prison is a dreamland of intelligent detectives. There are facilities to treat prisoners in a way that is not under U.S. law. The incarcerated prisoners may have to stay here indefinitely without trial. There was no opportunity to meet relatives and lawyers. On the other side, here it is seen as a stain on the United States because it is a serious violation of human rights, especially the torture and the detainees. For example, media outlets have reported stories of the prison where prisoner abuse of protected prosecution system have resulted in some prisoners being held for so long that they are known as the slaughterhouses. And although some leaders have spoken of the closure of the prison, Guantanamo is still working on it so far. On January 13, 2022, Mohamedou Slahi has been incarcerated at the U.S. Guantanamo prison for 14 years. He has been tortured for 70 days and has been tried for 18 hours a day for 3 years in a row. Before Salahi was arrested, he lived in Germany. He was arrested on suspicion of being a top operative of Al-Qaeda in connection with the September 11, 2001 U.S. attack, also known as the 9/11 incident, but so far nothing proved him guilty of the allegation, and in the past 14 years, he has never been prosecuted or convicted of any crime, but has been in prison all through. Mauritania Salahi was eventually released on the 20th anniversary of Guantanamo jail on January 11, along with 5 other inmates. Salahi was hit imprisonment for up to 50 years, no compensation for the duration of his life that was taken away. IACHR presents report towards the closure of Guantanamo. This report examines 3 main areas of concern within a framework of core international human rights: the right to personal liberty and security, the right to human treatment, and the right to a fair trial and judicial protection. Main human rights violations committed by the United States of America at the naval base in Guantanamo Bay, such as indefinite detention, the continuing and indefinite detention of individuals without the right to due process in Guantanamo is arbitrary and constitutes a clear violation of international law. Reasons of public security cannot serve as a pretext for the indefinite detention of individuals without any charge whatsoever. When these security measures are extended beyond a reasonable time, they become serious violation of the right to personal liberty. 2. Torture and other cruel, inhumane or degrading treatment. The United States government authorized the use of enhanced interrogation techniques, which during the early years include clamped confinement, while standing, straight positions, sleep deprivation, waterboarding, sensory deprivation, severe bleeding, electric shocks, include hypothermia, submarine, among others. Frostbitten has been used on prisoners who use hunger strike as a form of protest. A U.S. judge described frostbitten as a painful, humiliating, and degrading process. Adnan Varian Abdul Latif, who described the frostbitten as having a dagger shoved down your throat, committed suicide in Guantanamo in 2012. The fact that a state is confronted with terrorism should not lead to restriction on the protection of the physical integrity of the person. 3. Limited or no access to judicial protection. The United States has the international legal obligation to afford all persons detained under its jurisdiction a proper judicial proceeding to challenge the legality of their detention. The essential objective is to safeguard persons from the arbitrary exercise of power by the state. Therefore, the non-existence of effective domestic remedies places persons detained at Guantanamo in the defenseless position and jeopardizes the rule of law in a democratic society. 4. Military commissions, no due process. When the military commissions at Guantanamo exercise jurisdiction over the matter that federal courts should and could hear, there is a violation of the right to due process and to be tried by a competent, independent, and impartial tribunal, previously established by law. 5. No adequate defense. The attorney-client privilege is not respected at Guantanamo Bay. Prison authorities have access to private legal mail. Certain topics are prohibited in conversation between defense counsel and their clients, and military defense counsels are not allowed to have telephone conversation with their clients. This and other restrictions clearly constitute a violation of the right to an adequate defense. 6. Discriminatory regime. The United States has created a separate detention regime exclusively designed to hold and try foreign Muslim men, which appears to target individuals on the basis of their nationality, ethnicity, and religion. The hardest point is forced or coerced into signing a confession of terrorism. This is an ethical manipulation of the justice system, regardless of human rights principle. Section 44 states that a person shall have the rights in the judicial process as follows. 1. The right to access the justice system to its convenience, speed, inclusiveness, equality, and low cost. 2. The right to have one's case be considered legally, strictly, promptly, fairly, and with clear standards, especially children, youth, women, the elderly, people with disability, the poor, and the underprivileged shall have the right to be protected in proper judicial proceeding. 3. Fundamental rights in the proceeding with at least have fundamental guarantees on to be considered openly, adequate fighting opportunities, and objection to a judge or being considered by a judge or judge sitting in a plenary and selecting or copying judgment, ruling, or order to award to case. 4. The victim, the accusers, the plaintiff, the defendant, the parties, the interested parties, and the witness. In the case, regardless of sex, age, physical or health condition or any status, are entitled to appropriate treatment. 5. In criminal case, in the injured person, the accused, the defendant, and the witness have the right to protection and necessary and appropriate assistance from the state be investigated accurately, quickly, fairly, and with clear standard. The accused and the defendant are entitled to legal assistance from a lawyer or legal advisor with expertise. A temporary release is essentially a release unless there is a cause as provided by law, and to acknowledge the reason for the performance of the prosecutor's order or not to prosecute. Geneva, 11 January 2021. UN human rights experts today appealed to the new U.S. administration to immediately close the Guantanamo Bay Detention Center, saying the remaining detainees rested from rapidly deteriorating health by old age and mental and physical harm suffered in cruel and inhuman condition of imprisonment. Guantanamo is a place of arbitrariness and abuse, a place where torture and ill treatment was rampant and remains institutionalized, where the rule of law is effectively suspended, and where justice is denied. The very existence of this facility is a disgrace for the United States and the international community as a whole. Guantanamo should have been closed a long time ago. The UN expert says in 2003, the facility was holding 1,700 prisoners. 19 years later, 40 detainees still remain, but only 9 of them have been charged with or convicted of crimes. United Nations experts have consistently demanded the dismissal of the military commission and the closure of the detention facility at the Guantanamo Bay, holding them incompatible with the United States obligation under international law. We must not forget these detainees who have been subjected to torture or victims of comparable trauma and still languish in Guantanamo in a virtual legal limbo outside the reach of the constitutional judicial system of the United States. The prolonged and indefinite detention of individuals who have not been convicted of any crime by a competent and independent judicial authority operating under due process of law is arbitrary and constitutes a form of cruel, inhuman, and degrading treatment or even torture. Military commissions are still undergoing pre-trial proceedings on motion to suppress evidence resulting from torture. Trials are not expected anytime soon, as such proceedings are likely to last several years, leaving the defendant indefinitely held. Six have long been cleared for transfer, and one has recently been cleared for release through national security process. All remain imprisoned. The military commissions violate the requirement of impartiality, independence, and non-discrimination, and should never have been used in the manner in which they were deployed at Guantanamo. These individuals should receive a fair and public hearing by competent, independent, and impartial civilian court, previously established by law, the expert said. We appeal to U.S. authorities to prosecute in full compliance with human rights law the individuals held at Guantanamo Bay or alternatively immediately released or repatriate them while respecting the principle of non-refoulement. The expert said the United States must uphold its international legal obligation, conduct prompt and impartial investigation and alleged human rights violations, and provide redress and rehabilitation to those who have endured prolonged arbitrary detention or any form of torture or ill treatment.